Until 1990, visual artists in the United States lacked the legal right to protect their work from destruction or alteration. Specifically, they lacked moral rights, which are defined by Cornell's Legal Information Institute as the right to claim authorship of the work and to object any distortion, mutilation, or other modification of, or other derogatory action in relation to, the said work, which would be prejudicial to his honor or reputation. Unlike European countries, such as France, where artists' moral rights, known as droits d'auteur, had long been enshrined in law, the U.S. operated under a copyright framework that prioritized property ownership over artistic preservation. The lack of protection for moral rights led to works of art being damaged and in some cases destroyed. For example, property owners seeking to redevelop their land in the 1980s eradicated murals that had been painted as part of the Chicano movement of the 1960s and 1970s in Los Angeles, such as the mural Filling Up with Ancient Energies, created by Wayne Healy, George Yepes, and David Botello. Often located in low-income neighborhoods, these murals depicted themes of social justice, cultural identity, and resistance to oppression. Many were destroyed during urban renewal projects or repainted without the artist's consent, erasing key cultural and historical narratives. Then, in 1989, the Richard Serra art installation in New York's Foley Federal Plaza, known as the Tilted Arc, was destroyed due to public outcry over the potential physical danger presented by the sculpture.
The issue is, what is the governmental responsibility in arriving at a decision to place art that is paid for with public funds in a public plaza or other public place? I emphasize that we are not concerned with private art paid for with private funds to be placed on private property. The public, however, that term may be defined, should participate in the decision-making process to purchase public art with public funds for a public place.
The destruction of Chicano murals and the sculpture Tilted Arc underscored the vulnerability of public art in America. Artists found themselves powerless to prevent their work from being erased. VARA emerged from the Berne Convention for the Protection of Literary and Artistic Works, an international treaty created in 1886. The U.S. joined in 1989 as a result of increasing international trade spurred by faster communication and technology, precipitating the need for international uniformity in copyright law. The agreement granted two key rights to visual artists, the right of attribution and the right of integrity. The right of attribution refers to the idea that artists can claim authorship of their work and prevent others from falsely attributing works to them. The right of integrity ensures that artists can protect their work from international distortion, mutilation, or destruction that would harm their reputation. These rights apply only to works of recognized stature, a term that courts have interpreted to mean art with significant cultural or historical importance. Further influencing the creation of VARA was the California 1979 Art Preservation Act. The VARA Act was more specific than the Berne Convention as it only applied to the visual arts. The bill was introduced to the 99th Congress by Senator Edward Kennedy of Massachusetts and Representative Edward Markey, also of Massachusetts.
Rarely do we have the opportunity to respond to the needs of the creative artist with intellect, inspiration, and hands.
Kennedy highlighted the importance of adhering to the recently signed Berne Agreement, and he shaped the language of the bill to be fair to both creators and property owners. For example, photographs or works of art must be part of a limited edition of 200 copies or less, each numbered consecutively. Photographic images must be for exhibition purposes. Markey framed VARA not only as moral and cultural necessity, but also as an economic investment. He argued that preserving the integrity of visual arts would enhance its value, benefiting artists, collectors, and communities alike. While in Congress, the bill went through the House and Senate committees of the judiciary, where hearings were held. Legal experts, property owners, and artists testified. Supporters heralded the importance of preserving cultural heritage and artist rights, while opponents emphasized potential conflicts with property rights. Amendments to the bill were proposed, including removing works for hire from having protections.
The gentleman from Wisconsin yields back the balance of his time. All time having expired, the question is, will the House suspend the rules and pass the bill H.R. 2690 as amended? So many of those in favor signify by saying aye. All those opposed, nay. In the opinion of the chair, two-thirds of those present having voted in the affirmative, the rules are suspended, the bill is passed, and without objection, the motion to reconsider is laid upon the table.
Eventually, after debate on the House and Senate floor, VARA was passed on the last day of the 101st Congress as a part of a larger bill authorizing 85 new federal judgeships sponsored by Representative Robert Castaner and Senator Edward Kennedy. The act was signed into law on December 1, 1990 by President George Herbert Walker Bush. VARA exemplified the delicate balance between rights and responsibilities. Artists are granted the right to protect their creations, but this right comes with the responsibility of proving their work's significance. Similarly, property owners have the responsibility to respect artworks on their property, even if they wish to remove or alter them. VARA raises questions including to what extent should an artist's rights supersede a property owner's rights, and who has the responsibility to decide whether a work of art is recognized stature. These questions highlight broader societal debates about public art, cultural preservation, and urban development. VARA pushes society to consider responsibilities in preserving cultural heritage, even in the face of economic or practical challenges. One of the most significant tests of VARA came with the destruction of 5 Points, a warehouse in Queens, New York, by developer Jerry Wilkoff. For decades, artists worldwide modified 5 Points into a vibrant hub of street art with the permission of Wilkoff. However, in 2013, the murals were whitewashed without notifying the artists that created them, sparking outrage. The artists sued under VARA, arguing that their works were of recognized stature. In 2018, a federal court sided with the artists, awarding them $6.7 million in damages. The court ruled that the destruction of 5 Points violated their moral rights under VARA. The 5 Point ruling was a watershed moment for artists' rights. It established that street art, often dismissed as vandalism, could be protected as legitimate cultural expression. The case also underscored the responsibilities of property owners to consider the cultural value of art on their premises. Another test of VARA came up when Sam Kierson sued the Vermont Law School in the U.S. District for Vermont for covering up his mural portraying slavery. It was ruled that covering a mural without damaging it did not constitute a VARA violation. While VARA represents a significant step forward in intellectual copyright law, it is not without its challenges and controversies. Critics argue that the law's focus on works of recognized stature creates a subjective standard that is difficult to enforce. Anna Victoria Moreno, a law student at the University of Texas, contends that VARA should be amended with more guiding language surrounding art that the law applies to. She states that Congress were to amend VARA to provide more guiding language, it would give courts a clear and detailed framework when interpreting it. While some degree of flexibility must be maintained, additional guiding language would further promote VARA's purpose and ensure fairness. Additionally, VARA applies to only visual art, excluding other forms of creative expression like music and literature. Determining the cultural or historical importance of a work can be highly subjective, leading to inconsistent rulings. Furthermore, VARA does not protect graffiti or street art that is created without permission, leaving many artists vulnerable to the destruction of their work. Author and artist Peter H. Carlin stated in 1993 that artists already have great difficulty determining the meaning of work made for hire, as shown by the extensive litigation in this area. What about work only partially created for hire? Proponents of VARA argue that the law strikes a necessary balance, protecting artists' rights while respecting property owners' rights. They contend that the subjectivity of recognized stature is unavoidable in any legal framework dealing with art. The Visual Artists' Rights Act of 1990 represents a critical intersection of rights and responsibilities. By granting artists moral rights over their creations, VARA challenges us to reconsider how we value and protect cultural heritage. Its legacy is evident in landmark cases like 5 Points, which reshaped the landscape of visual art in the United States. In navigating the complexities of urban development, cultural preservation, artistic expression, and increasingly digital creations, VARA remains a vital tool for balancing the rights of creators with the responsibilities of society.